So the next case is case number 29091. Deborah Dunton versus Stephen Dunton. And both parties are here on this case, so the appellant will have 15 minutes to argue. You may reserve up to 5 minutes if you want to reserve time, let me know and I'll keep track of that, let you know when you get close. We've read the briefs. I'm trying to remember if there were children involved in this case. I don't think so.
There
Yeah, no. Okay, so we've read the briefs and we are ready to proceed if you would.
Thank you, Your Honor. I would like to reserve 5 minutes.
5 minutes, okay, thank you. You may proceed.
Thank you. May it please the court, I'm Janie Timonier on behalf of plaintiff appellant Deborah Archer, formerly known as Dunton. This is the second time this case has been back in front of the Court of Appeals. I believe that Judge Cook interpreted the Court of Appeals decision last time as a remand rather than a reversal. In any event, she asked the parties their view on coming back to her court. It was the appellant's position that the sole issue on the remand was her motion to modify the DOPO so that she may participate in the drop. It was the appellee's posture that the 2003 DOPO should be rewritten to conform to the divorce decree and that the plaintiff should not be awarded any part of the drop. In doing so, it made a very unequal portion, marital portion of Ms. Archer's portion of the retirement account. So she would have only ended up with $29,000 as opposed to Mr. Dunton's portion, which would have been about $500,000. Very disproportionate. In any event, to modify that DOPO that was originally put in 2003, this court found that the remedies at bar at that time were objections and appeals and various things, none of which Mr. Dunton exercised, and he sat silent and did not do those things. So when he came back and he did that 60B motion and the court found that it was timely filed, the Court of Appeals found that she had abused her discretion in that and reversed that decision. In effect, you said no way. When it got back to Judge Cook, she is basically telling this court no way.
How's she doing that? I mean, didn't we just say she can't vacate it, but nothing, you can still amend it?
What she did vacate it, Judge Cook did vacate that order, or that she did vacate the 2003 order and had it amended. So I don't believe that that's what this court said. I think that what this court was saying is that the opportunity, there was some disparity between whether or not that order was void or voidable. If it had been a void order, she could have vacated it because it was void ab initio.
So what you're suggesting and arguing is that the new entry before us that's being appealed is actually something that indicates that she vacated the earlier entry.
She had the parties come back when this court did a reverse and remand. She had the parties come back, and instead of saying that that 2003 order was in fact valid, she then vacated that order and had a new order put in place, in its place. So, in effect, she abused her discretion. She abused her discretion, I wouldn't say a second time, because she was not the original judge. It was Judge Dezo in the original case. After that, Judge Dezo had retired, and we're now in with Judge Cook. But when it came back to her, she took that 2003 order some 15 years after it had been in effect. Mr. Dunton had already retired. It had already been in payout status for 18 months. It had already been in effect for 13 years, and she vacated that order. So I believe that that was an abuse, because she didn't follow the law of this case.
Didn't she amend it?
She had the appellee amend it to something different than what that order
Isn't there
said.
a difference between amending it and vacating it?
Well, she vacated it and then had a different order put in its place. So I'm not sure. It's no longer in effect, so it has the same effect as vacating it.
Well, can I jump around a little bit here?
Yes.
And get to the heart of something else? Why is your client entitled to the DOPA? I'm sorry, entitled to the drop money?
She's entitled to the drop, part of the drop, not all of the drop,
Gotcha.
certainly.
And I misspoke.
Okay. Well, here's why. The parties were married for a lengthy period of time. During that time, Mr. Dunton was a police officer, and he used those years of service. That's part of the calculation for the drop funds. When they calculate the drop, years of service is one of the components in that calculation, along with his current pay, and it's a calculation. That's all I can tell you. It's mathematical, so. But he's benefiting from a marital asset. So his years of service that are performed during a marriage remain a marital asset. And even post-decree, if he's using that to the point where he's qualifying for drop benefits, she should be permitted to benefit from that same marital asset, where, in the same proportion as that marital asset is. It doesn't change. It's a marital asset. It doesn't change its qualities just because it takes on a different form. So, for example, if people owned mineral rights or something during a marriage, that to what degree it is, and later there's fracking on that, they still own whatever portion. It may have never paid for a substantial period of time, but maybe now it is. And if they maintained whatever it was, or they had it during that period of time, that now it's reaping benefits, it is.
Except that in your example with mineral rights, ordinarily there would be an evaluation of what that's worth. Either one side would keep the property or it would be sold or whatever. And you don't come out later and say, oh, gee, we discovered, oil there, and now it's worth 100 times more than we settled for it in the property division. So this was a marital asset that was evaluated, a particular evaluation was put on it for money, and now it seems like she's coming back saying, no, I want more.
Well,
Can I throw in the other factor? I think there was an agreement as to that value.
there was only an agreement as to what it was worth at that time. So,
But isn't that what's relevant, what it's worth at the time of the divorce?
It depends. And it's kind of sits silent a lot of times, and I'm sadly guilty of this myself, but when we do divorces and then we don't do dobos or QDROs in the right amount of time, then later, you know, who gets the benefit of the growth or the loss in the market when you're supposed to say it's this date to this date? So, for example, in this particular case, they said, okay, here's the divorce date, and at this time, it's worth this much. They didn't do the drop until, I don't know, 10 years
2003.
later. Yeah, 10 years later. So there's loss, there's growth, there's whatever it is. So she has this chunk of an asset, and then the court turns around and gives Mr. Dunton all of her growth during that 10 years, and then the next 14 or 15 or 18 or 20 after that too. That's complete unjust enrichment there. That's her asset. It was earned during their marriage. It's her chunk. So the growth should have been hers. And when that 2003 DOPO was created, there was things going on with their court case at the time, and when it was sent to the attorneys, and neither of us were their attorneys at the time, but when it was sent between the attorneys, it was submitted. It was waited the appropriate length of time. It was not responded to. It was then filed with the court. It was not objected to. It was not anything. So it wasn't appealed. There were a slew of remedies that were in place at the time, that none of which were acted on. And when that happens, when somebody sits on their hands, it's adopted by the court, and it becomes the order of the court. To come back 15 years later and say, oops, my bad, I made a mistake, that's not acceptable. This was in payout for 18 months before he even said, I want to file a 60B because there's a clerical error or something. This court said, no, that's not timely, and it is abuse of discretion. Just for the court under this to come back and say, no, we're gonna just take that out and we're gonna make it something different. It took away all of Archer's growth. It takes away all of her benefit to realize anything else from her portion of what was earned during the marriage, and that's all she's asking for. Because when those drop benefits were originally created, even though it's post-decree, all those letters went out through the association, and they identified themselves as marital assets.
Counsel, you've got 2 minutes and 56 seconds remaining for your rebuttal. At this point, you can continue if you'd like, or you can save that time.
I'll save it. Thank
All right,
you.
very good, thank you. All right, Counsel, you have 15 minutes.
Thank you. Good morning. May it please the court, my name is John Tarilla, and I represent the appellee, Mr. Stephen Dunton. So, Deborah's first claim is that the trial court committed error, abused its discretion, because it considered the original division of property order and determined that it did not parallel the terms and conditions of the parties' divorce decree. The thrust of her argument is that somehow or another this violates the theory of law of the case. And before I address the error of that notion, let me point out to you something particularly significant. The merit of the trial court's decision, that is, that this original division of property order was not on square with all of the terms of the divorce decree, has never been opposed or objected to by Deborah. And she has had more than 7 full opportunities to raise that objection. For example, if you carefully review the transcript of the hearing that the trial court conducted on March 9, 2018, there is not a single mention in any of the 61 pages of that transcript on Deborah's behalf that the division of property order perfectly matches the terms and conditions of the divorce decree, which, as this court well knows, that's mandatory. A division of property order is nothing more than an aid in execution of the judgment of the divorce decree. It's the decree that divides the parties' property. The DOPO is the vehicle by which the state is told, this is how you are to divide the pension. The property order tells you the terms and conditions by which to do that. It is not a new division of the divorce decree.
Counsel,
Yes.
what I'm wondering is, you said she didn't object, why would she object? Because there's no harm to her.
As you heard just a few minutes ago, there's a substantial amount being claimed.
No, the original DOPO before the drop and everything.
Well, what I'm saying is that since we were at this court specifically, I mean, the argument is that the trial court abused its discretion by overruling this court in some fashion. That simply is not what happened. If you look at the terms and conditions of your decision on December 6th of 2017, and I would refer you to page 2, paragraph 5 of that decision, where this court was talking about the trial court, and it specifically said, the court, trial court, vacated the division of property order, but did not address Mr. Dunton's request for relief in the form of an amended division of property order. His argument was that that property order doesn't match the divorce decree. And your court said to the trial court, you vacated the order, but you didn't do anything else, which you had to do. Page 7 of your decision, paragraph 18. Further, although the trial court's judgment entry purportedly vacated the division of property order, the court did not take the next step to enter an amended division of property order. That's what was wrong with Judge Dezzo's judgment entry. And finally, your court concluded at page 8, paragraph 18, moreover, this court's decision as to the first assignment of error puts the entire matter before the trial court. This court specifically told the Summit County Domestic Relations Court, we are sending this case back to you on all issues, the entire matter, not just the question of DOPO terms, but everything. The entire matter is the term used by this court, and I would suggest that it probably didn't use it with no purpose or meaning intended.
But in the same decision, this court also said that the 60B5 was inappropriate.
Correct.
That it should have been a matter that was appealed.
What the trial court, what this court said is, you can't get back to the trial court based on 60B, but we are telling the trial court, you should have conducted a hearing, you should have permitted evidence, you should have heard whether or not this division of property order actually matches the terms of the divorce decree. That's what it was sent back to the trial court to do on issue number 1. And in fact, that's exactly what the trial court did. It held a remand hearing. It was held on March the 9th of 2018.
Was that hearing on the motion to amend?
That hearing was based on this court's remand that, by the way, trial court, you have never looked at Mr. Dunton's question of whether this division of property order actually matches the terms of the divorce decree, which we recognize it must. So the court conducted the hearing, and it was a full hearing. It was an evidentiary hearing. Testimony was taken. Argument of counsel was made. And there were post-hearing remand briefs. And I would submit to you that if you look at the remand briefs, you will find that there is no claim anywhere in there by Deborah that the court's wrong, that the court should never have found the division of property order wasn't on square with the terms of the divorce decree. As a matter of fact, if you look at the record, after the hearing, the court permitted, on behalf of Mr. Dunton, on behalf of Steve, an amended division of property order to be prepared. That was hand-delivered to counsel for Deborah. The court said, wait 20 days to see whether there's an objection to it. There was none. It was therefore given to the trial court for consideration. If you look at the record, you will find the trial court then waited 30 more days and there was no objection interposed. If you look at the notice of appeal in this case today, there's no objection to the decision of the trial court being that the DOPO is out of variance with the divorce decree. That's not even before you. Now, it is clear on behalf of Steve that the trial court did exactly what it was told to do. Look at the division of property order and finally determine, does this match the terms of the divorce decree? If it does, so be it. If it does not, an amended division of property order should be issued, and it was. So, you talk about abuse of discretion. This court's decision on December 6th of 2017, at page 7, paragraph 15, told the trial court, although the trial court unambiguously retained jurisdiction to modify the division of property order, the trial court abused its discretion by simply vacating the order. In other words, you didn't do enough. As I said earlier, this court told the trial court you didn't take the next step. That means something. It means that you needed to consider the merits of the argument. Finally done on March the 9th. So, as a consequence, I submit to you that the first assignment of error should in fact be overruled. Now, let me get to the division of property order. First of all, I will refer to that as DROP, using the acronym because it's lengthy. DROP was created by a creature of statute on July 23, 2002. And that is and oddly enough, people have a hard time finding the law. It's in Chapter 7 of the Revised Code, 742.43. Now, Deborah claims that she should be entitled to drop, as you were just told a little while earlier, primarily because, geez, it seems unfair that I'm not getting as much money as my ex-husband got. Well, as Judge Carr pointed out, we divide the marital assets as of the date of divorce. That was 1993. Drop didn't even come into effect until 10 years later. So clearly, when these people reached an agreement to settle their case, they didn't talk about drop. They didn't talk about future benefits to be earned. They didn't exist.
But would you agree that pension is considered a marital asset?
Like that you get
Yes,
that.
I would agree with that.
At least the
However,
portion to which you might
but
be
let me
entitled.
make the significant distinction here. This is not a pension.
No, but it's,
It
one
is not
of
the
the
same as a pension.
calculations is based upon his years of service.
No, it's not. That's exactly wrong. And that's the claim that we've been given day after day after day when it comes to drop. I would refer you specifically to the statute, which says, and I will tell you, under section 742.442, which, by the way, the trial court said .22, that's not correct, .442. And I'll read it. For each member who elects to participate in the Deferred Retirement Option Plan, the Ohio Police and Fire Pension Fund shall determine under Division C1 of Section 742.37 of the Revised Code the monthly pension amount that would be payable to the member had the member elected to receive his pension under that division. In determining the pension amount, the fund shall use the member's total service credit and average annual salary as of the last day of the employer's payroll period immediately prior to the effective date of the member's election to participate in the plan. The point of that is this. Once you elect to enter drop, your pension and all those service credits, they stop. They're frozen. Your pension's calculated, it's done. Drop has nothing to do with it whatsoever. That suggestion is absolutely and statutorily incorrect. If you go to section 742.441 of the Revised Code, it says, a member who makes an election under section 742.44 of the Revised Code, that's the drop plan, that member shall continue in the active service of a police or fire department, but not, and I emphasize this, but not earn service credit under this chapter for employment after the election's effective date.
So counsel, I have 25 years as a police officer, I'm retiring now and going into drop.
You don't retire, that's the point. They continue to work.
I continue to work, I'm not getting my pension, and they're going to figure my drop based upon however many years I have right there, what I would have gotten as a pension check, correct?
Well, your pension is determined because you've now entered drop,
So
so
I
that's
get
done.
$2,500 is my
Whatever it
monthly
is, it
pension.
is, that's right. But drop, bear in mind, drop is not even related to a pension account. Drop is a 401k. Your money that goes into the drop comes from your paycheck that is earned during the period you work at drop. So you are permitted to deposit a specific percentage of your pay directly to that account. It is not a matching fund by the employer. It is not a matching fund by the state's pension account. It is simply a deposit from your payroll of how much money you want to put away into that fund. It has nothing to do with years of service or any of those credits whatsoever. It's simply a 401k deposit. That's simple. Whatever's in there is what you put in there.
Drop
No
is,
doubt.
drop is anything but simple. but-
Well, the
All right,
reason
okay.
it's not simple, and I will certainly confess to you that it's correct, is because the state has mandated its own form, and you can't vary the form. And so you can't create circumstances that fit the unique features of various divorces. But to suggest that the drop benefit is in some fashion marital property is entirely wrong. Now, you will also note that you see regularly in this case the reference to Meeker versus Steeles, because in the Meeker case, the drop benefit was divided in some fashion, or it was acknowledged to be possibly marital. And so you would ask yourself, well, geez, why could that be? I'm just standing here arguing that's not the case. Meeker's different, because in the Meeker case, excuse me, the parties actually agreed that they wouldn't value the spouse's share of this fellow's retirement funds until the date he retired, and they would determine it based on his entire benefits. That is, they would say, we will include the drop. That's not what happened in Dunton versus Archer at all. But in Meeker, it is. Now, there's another aspect of Meeker that I think is important, and it goes to show why, even if you wanted to agree with my colleague, that you couldn't. And that's because the evidence doesn't support the claim. Meeker recognized that if drop benefits, based on what those people agreed to, were going to be marital, you could never pay them out by a percentage. You've heard the term coverture fraction in divorce cases and pension dividing. And what that is the ratio between the number of years that you are in the plan and the number of years you were married while in the plan. And that percentage is supposed to represent the marital portion of the total pension account. That's because the account's all been earned during the marriage. But in Meeker, they said, well, you can't do that with drop, because in their case, because they agreed that all of his account would be included, some portion of that percentage is now being applied to non-marital property, that is property earned outside the marriage. And so Meeker stood for the proposition that if you are ever going to try and divide some portion of drop, you have to do it by a dollar amount. You have to prove the amount that it is. If you look at the history of this case,
Well, you're over time at this point.
thank you.
Thank you. And counsel, you'll have 2 minutes and 56 seconds.
The hearing that was held was specifically on what our interpretation of what your order was and exactly what was on remand. And that's why there was a disagreement, because I believe that you had reversed the first part and that she was not permitted to vacate that oath, and that we were there solely on whether or not Ms. Archer could participate in the drop. The drop, and you are correct, Judge Callahan, the drop is funded specifically from the employee's current salary, which we agree is separate property, and years of service. And in this case, for Mr. Dunton, that's a combination of marital property and separate property, because he did continue to work as a police officer after the divorce. So he's got about, I think, 14 years of marital years, and then, I don't know how many years afterwards of separate years. And there's a
Most could have
specific,
been was 8, so, so they were 14 years of his pension, they were married.
I believe that's the.
About ish.
Ish, yeah, I believe that's the, without checking, I believe that's the amount. And then there's a calculation that they make, and OPNF knows how, obviously, how to make that calculation, and they were able to give the figures on exactly what numbers would have been attributed to Ms. Archer, what numbers would be attributed to Mr. Dunton. And we're prepared to do that with the 2003 order, and which is why Mr. Dunton did not take the drop during the pendency of this case, because he wasn't about to share it. In any event, I think if what happens is we're playing ping pong between the courts, and the court is not designed to do that. That's why we have to follow the law of the case. That doctrine is divine to this court, to all courts, and I think that's why we stack the bench in higher courts with more legal minds, so that we get a better understanding of what exactly that we're dealing with, and we give higher courts deference and make the law of the case stand. And in this court, in this case, I think you got it right. And as far as Ms. Archer not objecting to the DOPO, no, she didn't. The problem is Mr. Dunton didn't object to the DOPO 15 years ago. He didn't object to it. He didn't appeal it. And that ship has sailed.
But what about his argument that the DOPO is nothing more than a mechanism to execute the decree? And the decree and the DOPO were obviously in conflict.
I'm gonna let you answer the question, but you're over time, so a short answer.
They may be in conflict. I'm not sure that they're in conflict. They may be in conflict if you look at the number when you say, this is how much it's worth at this time. But 10 years later, when they actually do the DOFO, I don't know if that meant the attorneys got together, they gave her the growth, the attorneys got together and they were doing something else and they agreed on this amount. That next number came from somewhere. It's a specific number. So it came from somewhere. It didn't just come out of the air. And it was never objected to, it was never responded to, it was never appealed. And here we are 15 years later, and that's the growth, I believe, from way back in 1992. And that should have been hers anyway.
Thank you very much. Thank you both for your arguments. Today, the court will take this matter under advisement and issue a decision in due course, and each of you will receive a copy of the court's decision. You can also check the Supreme Court of Ohio's website where the decisions are posted.
Thank you.
Thank you.